Does someone you care about have difficulty making medical or financial decisions for themselves? Are they easily confused, especially forgetful or otherwise at risk of being taken advantage of by others? Are you considering the possibility of adult guardianship? It's a difficult decision. You want to ensure that your loved one's needs are met, but at the same time, you're not quite sure what guardianship is or how to go about it. You're not alone. The unfortunate truth is that many older adults are unable to make decisions for themselves due to dementia, stroke, or some other serious medical condition. Often, adults living with mental impairments or other disabilities may lack the understanding to make informed decisions regarding their care. Additionally, children with developmental disabilities must have their rights protected and their needs met upon reaching adulthood.
Adult guardianship is a legal process where the court determines that an individual does not have the capacity or ability to make or communicate decisions for themselves. The court then appoints a guardian to make those decisions for them. There are alternatives to guardianship, such as powers of attorney or healthcare representatives that can also deal with these issues. However, if the individual has not appointed someone to act on his or her behalf before becoming incapacitated, a guardianship may be the only solution. The key difference between a guardianship and power of attorney is capacity. A power of attorney can only be assigned when the individual has full mental capacity or ability to select another person to make decisions for him or her. A guardian, on the other hand, is only appointed when a court determines that the individual is incapable of making or communicating decisions for themselves. A common situation where a guardianship is appropriate is that of an older adult that has incapacity stemming from Alzheimer's, some other type of dementia, or another condition associated with old age.
Aunt Laura's always been a very independent person since her husband passed away, and suddenly that was not the case anymore. She was becoming more dependent. She was to the point where she couldn't drive anymore. She was having difficulty remembering where to go when she was in the car. And then it fell to the nephew to get her pills, take her to the doctor, go to the grocery store. We sat down with Aunt Laura and said, you know, this is what we're seeing. Would you be more comfortable with us helping you out? And at that point she said she would like me to be her guardian.
Another common situation is the establishment of a guardianship for an individual with intellectual or developmental disabilities who reaches the age of 18. A person is considered an adult at 18, meaning they have the ability to make their own decisions. A person with an intellectual or developmental disability may not have that ability. They may require close supervision and assistance with many activities while being as independent as possible.
Jamie is my second son, youngest child, and Jamie was born with Down syndrome. Jamie's father and I became aware of his need for a guardianship as he became a teenager. We tried to be informed parents, and that can be difficult. There's a lot of information out there, but we were told a number of times that guardianship was a good protective measure that we should take steps to secure. Jamie is 25 years old, and as his mom, I would not have access to his medical, financial, legal records, legal being state providers, without my guardianship designation.
Another scenario that might require the establishment of a guardianship is that of an adult with a traumatic brain injury.
Traumatic brain injuries often happen from a motor vehicle accident, a catastrophic event, a motorcycle accident where the person loses consciousness, and sometimes they actually have to be put into a coma where they won't be conscious for a long period of time. And when that happens, first of all, they're not able to give power of attorney because they can't consent to that, and second of all, they're unable to make important decisions for themselves. In cases with traumatic brain injury, what we usually see is a temporary guardianship is set up. So an individual will petition to have temporary guardianship, which means they go to court, they file a petition. They often don't need to have a hearing because it's an emergency situation. Decisions have to be made quickly, both in the medical setting and in terms of the person's finances and insurance. And so typically you can waive the hearing for the temporary guardianship, and a hearing will be set later on if you decide to change it into a full guardianship. A guardian of a person with a traumatic brain injury is going to be paying their bills, they're going to take responsibility for their bank accounts, they're going to be the ones who are communicating with physicians about medical decisions for this person's care, they're going to be dealing with rehabilitation facilities, moving the person from the hospital to those facilities if necessary, as well as any of the day-to-day paying rent, filing taxes, those sorts of things that have to continue to go on while the person is receiving their medical care. At the end of the period that the court sets as guardian, the guardianship can automatically terminate if the person is back to full functioning and able to make decisions for themselves, or the individual can petition to turn it into a regular guardianship and will then be the guardian for the person, or someone else can become guardian at that point.
Because a basic human right, the right to choose and make decisions for oneself, is at stake, the law provides a formal procedure with built-in protections that must be followed before a guardian can be appointed. It's advisable to retain an attorney to guide you through this process. Attorneys who practice in family, probate, or elder law are usually familiar with guardianship law. Prior to filing a petition for guardianship, you should ask a doctor to fill out a physician's statement to describe the alleged incapacitated person's diagnoses, functional limitations, and areas where he or she may need a guardian's help. The court uses this document to make a determination of incapacity and the need for a guardian. Any interested person who is concerned about the welfare of an individual may file a petition for guardianship. He or she must also provide notice to the incapacitated person, his or her spouse, adult children, or anyone else entitled to such notice under the law. The court will then hold a hearing at which witnesses will provide sworn testimony to support the guardianship petition. If the evidence is deemed sufficient, a guardian will be appointed. Prior to the hearing, the court sometimes appoints what is known as a guardian ad litem to serve as an advocate for the individual and make recommendations to the court. When a guardian is appointed, the clerk of the court will issue letters of guardianship to the individual who is appointed as guardian. This document can be used to show banks, hospitals, and other agencies that the guardian has been appointed, as well as the role of the guardian in making decisions on behalf of the incapacitated person.
The court may appoint a limited guardian if it determines that the individual still has capacity in some areas. For example, if an individual is capable of making healthcare decisions but cannot balance a checkbook, the court can create a guardianship limited to management of the checkbook. In an emergency, a court may appoint a temporary guardian. The person seeking to establish temporary guardianship must show that an emergency exists, that the welfare of the incapacitated person requires immediate action, and that no other person appears to have the authority to act.
One scenario involving temporary guardianship was a case where a woman came to us and told us that her sister had gone in for a routine outpatient procedure, and unfortunately something had gone wrong. Because of that, she ended up in a coma. Now, when she went into the doctor's office that day, she hadn't planned to be out. She didn't make any arrangements to deal with picking her children up from school or dealing with her dogs at the kennel or day-to-day functioning. And because of that, the sister came to us and said someone needed to serve as her guardian. So what we were able to do was we took the sister to the court that day, filed a verified petition for temporary guardianship, and without a hearing, she was granted the guardianship of the person and estate of her sister. It meant that same day that she could go and work with the doctors to make decisions concerning her sister's medical care, She could go to her house and take care of her finances, deal with the schools to make arrangements for her children, take care of her dogs at the kennel, all of those sorts of things that this woman would have done if she were capable of doing it that day.
The guardian should be someone who is willing to act in the best interests of the incapacitated person, someone who is also willing, able, and suitable to take on this responsibility.
I'm the final decision in making healthcare decisions for Aunt Laura. I do talk it over with her, but when she fell, I was the one that checked her into the hospital, signed the papers for surgery, signed the papers to move her to rehab. So yes, I'm very involved with Aunt Laura's day-to-day care and all of her medical decisions.
A family member, such as an adult child, may be an ideal guardian. The guardian does not have to be a person with experience in guardianship or have specialized training. An attorney can help you understand the duties and responsibilities of guardianship. The court may take many things into consideration when determining who is appropriate to act as a guardian, including how well they understand the responsibilities of a guardian, their relationship to the protected person, whether they can act in the best interests of the protected person, and how well suited they are to manage the other individual's finances or medical needs. Once the guardianship has been established, the incapacitated person is now known as a protected person, or ward. The guardian must create an initial inventory and then file reports that update the court on the protected person status, as well as accountings of how money has been used to benefit the protected person. The powers and duties of an appointed guardian will depend on the type of guardianship designated by the court. There are three main types of guardianships. The first involves a guardianship of the person, which gives the individual appointed as guardian the ability to make decisions about a protected person's medical care, education, and other aspects of their personal life. For example, where they should live. The second type of guardianship involves a guardianship of the estate. This allows the individual appointed as guardian to manage the protected person's finances and other assets. If the protected person needs both, the court may appoint a third type of guardianship, known as a plenary guardianship, which includes guardianship of both the person and estate.
A guardian of the person is required to ensure that the physical and emotional needs of the protected person are adequately provided for. This includes seeing that they have food, clothing, shelter, medical treatment, and other basic needs met. The guardian of the person has the right to make healthcare decisions and, should circumstances warrant it, decide whether the protected person shall be removed from life-sustaining procedures. The guardian also has the responsibility to encourage the protected person's independence and to listen to recommendations from professionals concerning appropriate standards of care for the protected person.
Well, the biggest responsibility of guardianship for me is watching Aunt Laura's medication intake and keeping her balanced, keeping her happy and content where she is.
Jamie is a very proud employee of the South Bend Medical Foundation. He has been employed at the South Bend Medical Foundation for nearly 4 years, and indeed they are very, very proud to have him as an employee. Jamie is a donor attendant in their blood donation services. Jamie is independent in going to work through transportation on the Transpo public transit system in South Bend, and he goes off, as I go off to work, he goes off to work in the access bus that picks him up at our driveway. He comes home and is here for an hour to two before I get home in the evening. He feels independent, and therefore he becomes more independent.
The guardian may also choose the residence of the protected person. This includes placing them in a nursing home, group home, or other residential facility if the circumstances warrant. Guardians must obtain permission from the court any time they intend to move the protected person. The guardian of the estate should set up a separate bank account for the protected person and keep track of all money coming in and out of this account. All bona fide bills associated with the protected person should be paid from this account. This includes food, clothing, taxes, utilities, insurance premiums, and any and all day-to-day living expenses. Guardians must never mix the protected person's money with their own funds. The court may also require the guardian of the estate to post a bond to guarantee that the protected person's money will be handled responsibly and only to the benefit of the protected person. An inventory must be filed with the court after the order appointing the guardian of the estate has been entered. The inventory should include the value of all of the property belonging to the protected person. If there is any real estate or other valuable assets, the value needs to be reported to the court and may require a professional appraisal. The guardian must also file a financial accounting, as required by law, detailing how the incapacitated person's money has been spent. Often, the court will appoint a guardian for both the person and the estate of the protected person. This is known as plenary guardianship and follows the same guidelines already described. There are several reasons to end a guardianship. One reason includes an improvement in the capacity of the protected person. A guardianship can also end when the protected person dies, moves to another state, or if a new guardian is appointed for them. Any person, including the protected person, can ask the court to terminate a guardianship. A hearing may be held, and it is up to the judge to decide whether the guardianship will end. Guardianship is an important way to help people who cannot make their own decisions. Guardians advocate for services, assure that quality medical care is being obtained, provide protection from financial exploitation, and help ensure that protected persons live with security and dignity. This can be a complicated matter. Many of us may have a loved one in need of a guardianship at some point in the future. It's critical to achieve a balance between the need for protection and safety, while at the same time respecting the dignity and independence of the protected person.